Again, my name is Marco and I am with Whitco. We are a nonprofit based in the Bronx. We do a lot of different social services for the community, educational programs, and we've been trying to help small businesses for many years now in different capacities. We're happy to partner with Brooklyn Corporation A, who is here today to present about the Commercial Lease Assistance Program and to help answer some basic questions about how they can help you and your business.
Thank you, Marco, and thank you all for joining us. My name is Ashna Singh. I'm the program coordinator at Brooklyn Legal Services Corporation A, and I am part of the Community and Economic Development Program, where we manage and head the Commercial Lease Assistance Program, which I will get into in just a minute. So Brooklyn Legal Services Corporation A, Brooklyn A, it's a mouthful, but we go by Brooklyn A, advances social and economic justice and community empowerment through innovative, collaborative, neighborhood-based legal representation and advocacy. Our unit, the Community and Economic Development Unit, has been around for 51 years, and we provide high-quality, low-barrier legal services to our not-for-profit organizations, CDCs, coalitions, and small business owners, which is why I am here today. Our focus will be on our small business program. We provide free, high-quality legal services for small businesses, nonprofits, entrepreneurs, or aspiring entrepreneurs impacted by the incarceration system. So that includes if you've been previously incarcerated and you want to start a small business, or if someone in your family or your friend group and you feel impacted by the system, and of course, our small business and nonprofits in general. Today, I'm here to discuss the Commercial Lease Assistance Program, which is, again, a program headed by us here at Brooklyn A in the Community and Economic Development Unit, and this is our program to support our small business owners. What do we do within this Commercial Lease Assistance Program? So this is not an exhaustive list, but our services include helping small business owners, especially during COVID-19, but have been supporting them since before the pandemic and will continue to support them as we get into the pandemic. First and foremost, we are here to help our commercial tenants and landlords to negotiate equitable agreements so that they don't need lawyers through the term of their lease or contract. That is the ultimate goal of our program. However, while we are here for our small business owners. So we can do lease reviews, we can do amendments, we can do assignments, we can do terminations. We can help negotiate a new lease or a lease renewal. We can draft equitable payment plans so that you can support your business going further. We can help formalizing any oral or unwritten agreement. So you do not need to have a written lease to participate in our program. We are here to help you navigate the new laws that are coming around during COVID-19. And as we move forward with the eviction moratorium that recently ended, we are here to just answer any questions you have. We are also here to help you with your applications for any government-funded relief programs and grants. And first and foremost, especially here to help you if you're facing any landlord harassment or breach of contract. I'd like to emphasize the biggest point, which is you don't need to have an issue. You don't have to be in crisis. You don't have to be having an emergency with your small business, even to just learn what your lease says, because many of our small business owners couldn't afford an attorney at the time or sign something 20 years ago, 10 years ago. We are here now to read your lease and tell you what it says. So again, I'd like to emphasize, you do not need to have a problem. Of course, if you do have a problem, come seek our services. It's very important that you come to us as soon as you know a problem is coming. However, we want to catch the problem years ahead, right? Year ahead, 2 years ahead, 6 months ahead. So we're not in a crunch time position. Again, come if you have an emergency, but also come if you don't. That's actually the most critical time to come see us. Who do we serve? All New York City small business owners. To be eligible for our program, you just have to be a small business according to the U.S. Small Business Association, which is every single small business owner in New York City. You have to be located within the 5 boroughs. You can't be a franchise establishment, and we prioritize based off of need and affordability. We do not turn away anyone based on income. But we do prioritize our business owners using annual household income of all small business owners using the federal poverty guidelines. So all of our small business owners must be below 500% of the FPG. However, we do not turn anyone away. So again, it's I like to say that any and all small business owners under the sun in New York City qualify for our program. It's very unlikely that a small business would not qualify. So please come seek our services if this is you. Small business owners that we serve and prioritize, especially are small business owners who are women, minorities, immigrants, veterans. If you speak English as a second language, we have our services supported in all languages. As you can see here today, we have Spanish translation, and we have all language translation throughout services, from the point of contacting us all the way through speaking to an attorney, and in conversation, whatever language you speak, we can support you. In-house, we have Spanish, Hindi, Urdu, French, Mandarin, and any other language can be supported. We have several translation services as part of our program that we're partnered with. So language is never a barrier to seek our services. We prioritize our business owners who have an oral, unwritten agreement. Come formalize your agreement with us. It is completely okay to not have a written agreement or a written lease. That is what we are here for, to explain to you that you still have rights and we can formalize something so you're protected going further. If you're facing any breach of contract or landlord harassment, you come to the top of our list. We want to make sure that stops immediately. And if your lease is expiring soon, definitely come see us. So the time of renewal, it's not crunch time for us to, negotiate any better terms. And as there's rezoning going on, it's very important that you come seek our services, especially if you're in a rezoned area. And of course, we are here for our legacy businesses. So if you have been in your neighborhood 10 plus years, you're incredibly important to your community. And so you're incredibly important to us. So again, we are here for all small business owners and any small business owners in New York City. This is the most important part. How do you register for our services? We have a very brief application registration form at nyc.gov/comlease. And if you have any issue at all with the website, you can email us directly at clahelp@bka.org. And most importantly, you have Marco and Yasmin here and Wedco to help you sign up for services. And when you sign up for services, you can see that at the very end of the questionnaire, there will be a question on how did you hear about us, and that is where you will write in Wedco. So make sure that you have several options to receive our services, and when in doubt, you have Marco and Yasmin who can help you with that.
Thank you, Ashna. My name is Jing. I'm a staff attorney at BKA. As Ashna has already mentioned, with the expiration of the eviction moratorium on January the 15th for both residential and commercial tenants, the court is allowing landlords to go forward with their eviction action. However, I would like to point out there are defenses available to the eviction actions, which our attorney will discuss with each of our clients in more detail, but I'm just going to go through one of the easier ones today, which is the notice requirement. So there will be notice requirement required by the law, as well as commercial lease itself that you sign between you and your landlord that can be good defenses to look to. So under the law, a landlord must give a 60 notice to vacate a month-to-month tenant who has been in the leased space for more than 1 year, but less than 2 years. And the notice requirements is 90 days for tenant who has been in the space for more than 2 years. And the landlord must also serve a written 14-day rent demand before starting a summary non-payment proceedings in court. If the landlord fails to meet the notice requirement before starting the action, the commercial tenant can use the lack of proper notice defense and ask the court just to dismiss the action. And the main and primary protection to our commercial tenant is under the non-residential tenant harassment law. This law is codified under New York City Admin Code 22-902. And under this law, the small business owners who are commercial tenants can seek relief such as injunction in court if they are experiencing harassment from the landlord, or they can seek damages up to $50,000 per occurrence. However, even though the remedy might seems to be great here, in order to receive the relief, the small business owner needs to be proactively seek the relief in court, which means they have to find a litigation counsel or willing to appear in court pro se. And our team at BK here is the most consequential defenses for commercial tenants. We are advocates for small business owners. So instead of taking on all the issues with your landlord yourself, small business owners should sign up for a service and work with one of our attorneys. So I always hear my clients say, I have a really good relationship with my landlord and I don't need an attorney. However, it is important to distinguish between a personal relationship and a professional relationship. In a personal relationship, we value the quality of connections with each other and you feel the closeness. However, the closeness is very subjective. So we care about each other, we want the best out of each other. But in professional relationships, we might genuinely like the other person, we might really like the landlord. However, the relationship with your landlord and you is to further each other's professional goals. So for the landlord, the aim is to make money through the rent that our commercial tenants are paying every month. And for our commercial tenants, their goal is to have a space to operate business and generate more income and make a living. So sometimes the subjective illusion that I have a good relationship with my landlord might interfere with our commercial tenants' professional judgment. And in fact, there are some landlords who might be misleading the tenant into signing and agreeing with unfavorable terms by appearing to have a good relationship and by appearing to be very helpful and very understanding to the tenant's situations. Just because the landlord is nice or friendly does not mean that they are going to cooperate or give real concessions. Many landlords are friendly, they might say, don't worry about it, but they might just file a lawsuit for arrears behind your back. So it's very important to keep focused on what is the best for your business, not your personal feelings, and don't rely only on the landlord's words. You should try to get all agreement in writing. So our attorneys at BKA can be directly involved in that relationship because we are an outsider. We are we can more able to judge what is the best for your business. We are not going to be interfere our judgment by the personal relationship that a commercial tenant might already have with their landlord. However, on the other side, we are perfectly understanding that we are willing to work in the background if that's what our client wants. And we are willing just to guide our client into making the best choice for their business. So what to do if you receive an invoice, a bill, or a statement from your landlord that your landlord is saying that you owe certain amount? Here's what you need to do. You always want to cross that out, write dispute it, and send it back to the landlord. Because without doing so, your landlord might make their case as accounting stated, which means that since you did not dispute amount, you agree to the amount that is correct. Therefore, you should always dispute amount, even if you indeed think it is correct, just so that you can retain this defense in the future. And now I will hand over to my colleague Alex, and she will go over more brief advice that will be very helpful to our commercial tenant clients.
Thank you, Jing. Good evening, everyone. My name is Alex Grzebek. I'm a staff attorney at Brooklyn A in the CED department, and I'll continue along with the brief advice. So if you get a notice, the number one thing we tell our clients is don't ignore it. You want to know who it's from, whether it's a notice from the court, your landlord, or your landlord's attorney. Usually an easy way of identifying whether the notice is from a court is to check for an index number, which is usually located in the top right-hand corner of the document. That will be the identifying number of the court case. You would want to check the notice to see if there is a deadline or a hearing date. If the notice is from the landlord, this might indicate that they are preparing for court. There are certain statutory requirements to bring an eviction notice, and you want to pay attention to those dates in the notice. And if it contains a threat that you must vacate or surrender the space, do not, and I repeat, do not do so. Usually the space is your only leverage in negotiating with your landlord. So you want to negotiate before you leave your commercial space. So as we mentioned, there is a commercial tenant harassment law. So if your landlord makes threats of physical harm, you want to call the police immediately and have this documented. If they keep showing up to your business and demanding any unpaid rents or just generally disrupting your business, you can review your lease to see whether there is a provision about your landlord notifying you before entering your space. Some leases do provide the landlord the right to enter in case of emergency or other reasons without necessarily giving you notice, but generally the idea is to document the harassment so you can use it in the future. Repairs. So generally the lease will cover whose responsibility it is to cover repairs in the commercial space. If it is the landlord's responsibility, check if there is a time frame included for when the landlord needs to repair by. If there is an incident and property is damaged, the first step most likely would be to contact your insurance company and file a claim. Some leases require tenants to contact insurance companies before they contact the landlord when it comes to certain repairs. But after contacting the insurance company, reach out to your landlord and see if they will help you in correcting the damage. Regardless, you will want to document the damage, the date it happens, and keep a record of that for the future. And now we're going to open it up to Q&A with Jing and I believe.
Speaking of the repairs, should a tenant make the repairs themselves before they take the steps that you described, contacting their insurance company or contacting the landlord?
It really depends what the lease says and whose responsibility is for repairs. Before making the repairs that are necessary, I would say at a minimum, contact your insurance provider and file a claim before you expend any sort of source of money into it. Then, like I said, I think a general lease review to determine whether, because if it is your landlord's responsibility, you'd want to contact them before putting in the money into the work in case that they just turn back and refuse to pay. It's a lot easier to have them cover the costs than try and chase your landlord for reimbursement down the line.
You know, I think a lot of folks are interested in knowing what to do when they get a notice. And you know, you covered it in one of the earlier slides. And I was wondering, you know, in essence, like folks don't know how to respond. We are trying to get them connected to the CLA program. Is there something else that they should be collecting before they approach the Brooklyn A team?
Well, one main thing is just to preserve all the documentation that you ever receive with your landlord and preserve all the emails, text message that you have with your landlord, just so that you know what was going on, what your landlord communicated to you. And if you had an oral communication with your landlord, try to follow up with the email just to confirm or write down a memo, just so that you have a record. And even if you don't have the record, that'll be okay. Always try to sign up for our service the minute you know you need our help, and we can reach out to your landlord and ask them to provide the documentation if you happen to not be able to locate it. But preserve the record. That is very important, I would emphasize.
Great, thank you. Another question that has come up a lot is landlords. We're hearing that some landlords in and around Jerome Avenue are now starting to ask for additional utilities, for example, sewer, or a higher percentage of real estate taxes. What should those business owners be doing?
First of all, look to the lease. Usually the cost of utilities and especially real estate tax are addressed in the lease. So they will spell out how much the tenant is obligated to pay, and this is a signed document, the landlord could not unilaterally just raise the real estate taxes or utilities by her or himself, and never sign a notice for increased payment received received from the landlord, and don't be carried away by the friendliness from your landlord, and don't try to be helpful to your landlord by paying more money. And just when your landlord sends you a bill that you believe it's more than you are obligated to pay, always dispute it. Always write dispute, cross the amount out, and send it back to the landlord.
Thank you. So some of the businesses that I've talked to that had this issue, for example, they are, they sometimes they're behind on rent, or they feel sort of obligated to kind of go along with the flow. Is it possible if they send a check that now covers the higher rate, is it still possible to later on, after they've had their lease reviewed by your team, for example, and it shows the fixed percentage that you had talked about, for example, would it then be possible to sort of make that adjustment retroactively, or are they essentially now sort of signing on to a new agreement with the landlord?
I believe what you meant is by saying the tenant paid an extra amount, but the best case scenario is that did not sign any side agreement into agreeing to pay the higher amount from this point out. If that's the case, our attorney can definitely reach out to the landlord just to set the record straight that the tenant was being very helpful, therefore prepaid the utility cost or prepaid the rent in advance. And according to the lease terms, this is the amount that the tenant is obligated to pay, and we pay this extra amount, therefore the extra amount should be applied as a credit to reduce future rent or utility expenses.
The only thing I would add to what Jing has said up until this point is to just kind of let businesses know that any contract is negotiable. You can negotiate anything, any terms. So don't be fearful that you somehow lock yourself into an agreement by paying that increased, utility bill 1 month, 2 months, and then you feel stuck in that cycle to feel obligated to continue paying that increased price. Anything's negotiable, and that's something that our attorneys could help small businesses with.
So what is the process that folks should be expecting once they send out an email, once they sign up for the CLA program? How will folks be notified?
Yeah, so once you register for the services on the website, which I will again drop in the chat, or Alham, if you can drop it in the chat. After that, it'll be approximately 48 hours in which you will receive an email based off the email address you inputted into the registration form, and you will receive a phone call if we do not hear back via email. And then we attempt to make our calls 3 to 4 times within a 2-week period. We understand our small business owners are very busy, and we want to make as many attempts as possible. And after that, you'll just have a 15-minute to 20-minute brief conversation with our intake specialists, who will ask you more detailed questions about your problem, your lease, just so we can get as much information as possible to, decide how to move your case forward. And then between a week is when you should hear from an attorney. So again, just to recap, about 48 hours after registration, you'll hear from a team member of ours. And after that, once you complete a phone call with them, and we have a better understanding of the problem you're facing or the help you're searching for, then you will speak with an attorney after that. So about a week from registration, you'll speak with an attorney, and about 3 to 4 days after the phone call.
Amazing. Thank you so much. And what should folks be expecting in terms of documents? Do they need to have their lease ready? Can folks that don't have a lease apply for this program?
Absolutely. You can definitely apply for this program if you don't have a lease. If you have a lease, it is always better, to have that ready to go. Once you have the phone call, then usually the next step is our intake team will, request for you for your lease. That way we can share it with the attorney. but there's no, there's no rush to this process. So it's completely accommodating to the client's timeline. And we want to meet our small business owners where they're at. So no documents necessary. However, if you have a notice, you have a lease that you have questions about, a letter, anything like that, that is also something good to come prepared with, just so that our intake team can learn a little bit more about it, as well as share it with the attorney quickly.
A lot of questions that we have heard have to do with those repairs. So we've talked a little bit about that and about the utility bills. But another question that keeps coming up is like, what do I do if I owe rent?
If you owe rent, don't just try to like delay it. If your landlord is not like actively pursuing the arrears, don't try think your landlord let it go. I would suggest, first of all, you can always sign up for our service that we can help you to renegotiate the arrears, the settlement terms, maybe possibly reduce or have your landlord waive portion of your arrears or reduce your future rent for a period of time. In the same time, if you really believe that your landlord is being very helpful and understanding, you might initiate the conversation with your landlord and ask for real concessions, such as maybe let you pay a portion of the rent for a couple of months, or asking for a waiver of a portion of arrears. The worst case scenario, ask your landlord to defer the payment with no interest. Tell the landlord the hardship you have been suffering, and try to have the landlord understand and come up with like a payment plan with the landlord. But at the same time, it's very crucial for our business owner to know that BKA is here. They can always sign up for our services, and we can take the frustration out of the personal relationship between you and your landlord. We can step in there and just to be like a neutral voice and use our professional judgment to come up with a reasonable offer that will satisfy both you and your landlord.
What about for folks who haven't signed the lease yet? Is there anything that CLA can do for them?
Yes, absolutely. We help small businesses review potential new lease agreements as well. So even if you don't have a lease agreement, you want to memorialize it, or you're looking to move into a new commercial space and you're reviewing a potential new lease, that is absolutely something our team can help and review, your rights and obligations under it, and even negotiate better terms for you.
There's a couple questions about harassment. What is that? What could that look like? And what should folks be doing to sort of document any cases of harassment?
So one example would be landlord threatening you to lock you out, or just verbal threats for like, if you don't pay, I'm going to do so and so. Like, always document. And if the landlord is using physical violence against you, always call the police, even though the police might not be helpful, but the police will issue a report, and that will serve as documentation of what took place on that day. And once again, you should sign up for our services, and we can take the documentation you have and issue notices to a landlord to make them stop the harassment. And if they don't, we could help you to get the remedies that you might be entitled to due to the harassment that the landlord is, the harassment action the landlord is acting against you.
The way I like to close off is kind of ask, what is the one advice you would give to a small business owner on the call right now?
Just come speak to us. You have a team of 16 people ready to assist you, excited, passionate. This is what we do. We breathe commercial leases in and out. We talk to landlords every single day. You have experts that are ready to assist you. They're excited about assisting you, and you don't have to go through this process alone. So definitely reaching out to us for services. And you have an amazing community-based partnership with WEDCO. And they're an organization that are there to support you, to help guide you towards us, as well as additional resources. So please take advantage of that.
One thing I would say is always remember your landlord is your landlord. He or she is not your relative. She or he is not your family members. Never agree to anything right off the spot. always take the time to assess on what is offered and what is asked for. Ideally, always ask the terms to be written down, never just orally agree to something, or never without agreeing, just pay money upfront to the landlord. And the best case scenario is sign up for our services, talk to one of our lawyers, and we can help you review what is offered and what is asked for so that you can make the best decision for your residents.
And my last parting advice is please don't ignore notices, especially if they're court notices. You want to get ahead of the problem. And like's been said, I'll reiterate it here now, please reach out to us. We'll help you through even transactional litigation support. We have some great referral programs for pro bono litigation partners that we could put you in contact with. And at the very least, we could get ahead of the problem before it's a bigger one and it's too late. So reach out to our services, get connected with an attorney, speak to us, and we'll do our best to remedy the problem.
I want to thank Brooklyn Legal Services Corporation A. Please contact us at the same number or sign up at the website that Aham shared online in order to sign up for services to receive help from the good people at Brooklyn Legal Services Corporation A. And then finally, our team at WETCO is trying to help businesses in different ways. So for some folks who might be trying to find ways in accessing grants or loans to help with some of their expenses, including rent, we are going out there on the field helping folks apply, make those applications. So give us a call at that number, 347-973-0945. Share with us any needs that you might have, and if it's something that we can't provide or Brooklyn Legal Services, then we will try to connect you to those folks. I'll hand it back off to Brooklyn A in case they want to say any last words. But we thank you for joining us tonight.